I think people will join. Let me go ahead and start anyway. I'm going to share the screen here. Okay, can you all see my screen here, Uma?
Yeah. Yes.
Okay. This is some topic I had been interested for last several years. I've given several talks on this. And it's kind of important topic. When you casually look at it, it seems like why we need to do all this. But as you see in my presentation, there are why it is so important to have it. One thing I have noticed in our Indian community, and I guess to some extent local community, why we should discuss all this. People are in denials, people have stigmas about this, and in general, people have apathy. And it is a challenge. And some examples of this are, I'll never get critically ill, physically or mentally, People, when we first came here 40 years ago, everybody say we're invincible. We'll never have critical illnesses and we'll not have any problem. And people think, I don't want to think about this end of life issue. For some reason, there is a stigma about the word end of life and dying. I don't care what happens to me when I die. Let my spouse and children take care of it. There is another explanation I get all the time. And then I have better things to do than planning for critical illness and disabilities. And some says, I don't believe in living well. So it's a real challenge. Okay, why there's the importance of understanding advanced directives. Of course, this term is used, living will and advanced directives are interchangeably used. That's the same thing. And we have to remember that it's not just signing the form and getting two friends to witness it. It is understanding the ethical issues like our moral issues and obligations. It not only addresses your values and views about your health and end of life issues, it also addresses your family, interpersonal relationships, and big pictures of its impacts. It's both logistically and financially on the healthcare of our nation. We spend millions of dollars on people who linger on, sometimes for years, who are either brain dead or in vegetative states. This is not primarily an issue for the seniors, but for all age groups. We have several situations in our community at present where so many people are at the end of life issue, they're vegetative, lingering on for years, going back and forth to the hospital, getting admitted to the ICU, and millions of dollars are spent on the healthcare. And their life is very miserable. More importantly, the life of the spouse and the family is miserable. This whole concept of addressing end of life issue is gradually changing. Prior to 1990, when the Supreme Court enacted the Patients Self-Determination Act, patients and their families could not decide how they could be treated at the end of life. During the past 30 years, our thinkings have changed. And most of us are placed in writing the advanced directives. As we go forward in the next 10 to 20 years, we'll be seriously thinking about physician-assisted suicide and euthanasia. Nearly 10 states have legally enacted and approved physician-assisted suicide. And we'll talk about this some more. You know, getting to this, I think about the situations in India, especially 30, 40 years ago. You know, in India, the situation is so different compared to the situation here in America. Having practiced for the last 50 years in America, the situation is a lot different. The kids are not taking care of their patients, and somebody staying in Florida, somebody staying in California. Hey, doc, we want to do everything for my dad. They're not seen their dad or mother for last 10 years. Situation in India in the past, and to some extent now, was a little different. They always took care of their parents. There was a joint family system, and there was no secondary payments. There was no insurance were not paying. They had to, sorry, I'm doing all this because I'm doing the administrative job and admitting people. People are joining a little late, but that is expected. So I think that in India, there was another thing in India that was kind of unique. People wanted to die at home amongst the family. And I've seen that with my grandparents. They were brought home. And when you're brought home, there's not that intensive care. I use the word careful neglect. And people die peacefully at home amongst the family. So that was 2-3 different things in India. Okay, death with dignity. Let your wishes be known. Complete your living will. Advanced directive and living will, as I said, is the same term. And what are the benefits of having a living will? 7 benefits of living will. Number 1 is we can refuse treatment that you do not want. There are numerous number of reasons why people may not want certain medical treatment. It could be just do not resuscitate, and we'll talk about this some more, DNR. Or you may not want a feeding tube. Some treatments may be against your moral or religious belief. A living will gives you control over the treatment that you will accept and those you will not. Second benefit is know your outcomes. You never know when an illness or disease might strike, or you may be in an accident that puts you into a situation where you cannot make your healthcare decisions. Having a living will in place assures you that incapacitation will not make outcomes a guessing game. You know what to expect because you have specified it.
Can I get you my water? No, yes. My check, so this the small one is not.
Okay, the third benefit.
Small piece is not big one. Maybe it's come tomorrow for the cutting and Monday for the throwaway.
They use some money today.
Prevent arguments among family members.
For this later. Did you give me the check?
Your family cares about you, but different family members may have a different opinions about your best treatment. By creating a living will, you can eliminate any disagreement. The fourth benefit is make the decision easy for your family. Since you have a specified what you want, it will be easier for your family to accept your wishes. You have limited their options, so the decision won't be as difficult as they might have been. Of course, the fifth benefit is ensure your doctors follow your wishes. With an advance directive, your doctors will do what you wanted them to do. They won't want to do what they simply feel is best for you. You are in control. That's very important, not your doctor. The sixth benefit is you authorize your treatment. There are many procedures that require authorization from the patients. You can make this authorization in advance in case you are incapacitated. You can ensure that you will get the treatment you need and want. Of course, the seventh benefit is to eliminate the financial problems for your family. That's a big problem. Though our insurances pay for almost 70-80%, but still there are so many other expenses that are not paid by the insurances. And more importantly, it's such a stressful condition on the caregivers. So many of these caregivers themselves need care themselves, medical care. And this can become a very expensive thing. And you can make your decision in advance that will eliminate or minimize the cost of care for you. What are the types of advance directives? There's a durable power of attorney for healthcare, appointment of the healthcare agent. These are the different terms. You know, several of you know the power of attorney, financial power. This is for the power of attorney for the healthcare. And we'll talk a little more about this healthcare agents, how important they are in making a decision when we are not in the position to make that decision. So the other living will and advanced care plan, and there's a post physician's order or scope of treatment and universal DNR. We'll be addressing all this later on in more in details. Many people think that they do not need a living will unless they reach a senior citizen age. This is a misconception. Really, you need to start thinking about this earlier, even at the age of 50, 60, 70 years old. Don't wait till you're 85, 90 years old when you cannot think properly and make a proper decision. Life is unpredictable and often uncontrollable, which is enough reason for adults of any age to invest in a living will in order to protect themselves when they had a bad fortune arises. We have several incidences at the younger age, 50, 40, 50 years old. People have accidents, brain death, and they are on ventilator for several years. And I'll show you some examples. And some of them are very much publicized in the newspapers in the past 25 years. And some of the examples are, Terry Schiavo, a 41 years old Florida woman who had a cardiac arrest at home, was in a persistent vegetative state for 15 years before her death on March 31st, 2005, was at the center of the political, legal, and media tempest over the removal of feeding tube. And those years, 2005, people didn't have much concept about the living will, and there were a lot of political, legal, and media tempest about that. And other example is Karen Ann Quinlan. After consuming an alcohol and sedative, this is a 21 years old, stopped breathing and lapsed into a coma. After 5 months, doctors diagnosed Quinlan as being in a persistent vegetative stage. And I'll explain that a little more later on about what is a persistent vegetative state. Her parents, who believed there was no chance of returning to consciousness, requested that Quinlan be disconnected from the life-supporting machines. When the doctors refused, they took the case to the court in what became one of the right-to-die case in US legal history. Court ruled that she should be taken off the life support. Her life made headlines and provided the groundwork for numerous similar such cases. Of course, the Quinlan story did not end there. After winning off the respirator, she survived for 10 years, dying of pulmonary failure. So can you imagine the family going through so much stress and trauma for the last 15 years? The third famous case was Nancy Cruzan. 8 years after an auto crash that left her vegetative state, 6 months after the United States Supreme Court ruling on the right to die, and 12 days after her parents won their fight to remove the feeding tube that was keeping her alive. Nancy Cruzan died at the age of 33. Miss Cruzan's case became the centerpiece of a bitter debate about how and when families can decide to withdraw nourishment or medical treatment to bring about the death of incapacitated loved ones. We had a situation here in Nashville where the patient was kept on a feeding tube and a PEG tube, the G tube, and feeding, and very miserable, sitting on the chair all the whole day for 4, 5, 6 years, and going in and out of the hospital, staying in ICU for a week or 2 weeks. It was very miserable situation for the caregivers. The US Supreme Court case of Nancy Cruzan not only changed the path of Cruzan family, but it also resulted in the Patient's Self-Determination Act. This was passed in 1990. Act that affirmed the right of adults in the United States regarding their healthcare wishes, especially the adults with the capacity. They may choose or refuse any medical or surgical procedure, or they may make advance directives and transfer their decision-making authorities. Of course, the durable power of attorneys for healthcare, also known as healthcare agents. We are talking about assigning a healthcare power of attorney. Healthcare power of attorney, we usually needs this person because at certain stage in life, we cannot make a decision for ourselves. And usually it's your spouse or children. And you can make decision, they can make a decision about your health care. You will be the primary decision maker for your health care. However, you need to express ahead of time to your family, healthcare providers, and close friends. And we'll talk about this caring conversation a little more. And you'll have to put this in writing and witnessed by two people. If you are not capable of making the decision, then you need to appoint a healthcare agent who will make the decision at that time. Now, usually it's your spouse, as I said, or you can have your one child. And I have seen the situations in my practice where there are 4 or 5 children. Each one has a different opinion, and they're in fight, so much fighting as to what's the best for their dad or mom who's dying. And it's a big legal problem. So it's best to appoint one of your family member or 2 at the most as your healthcare power of attorney. The next topic is about the caring conversation. This is what I was talking about. As you begin to think about what you want to speak for you, you think of the following things. Number one, you reflect on your personal experiences, values, and desires and preferences. Talk to the person you are considering as your agent. That's a healthcare power of attorney, agent. Appoint the person who will speak for you when you cannot speak for yourself, using a durable power of attorney for healthcare. Act by sharing your decision about your healthcare preferences with family, friends, healthcare providers, clergy, attorneys, or desired by reviewing your preferences on a regular basis. You know, one thing we decided, and we have done this in our family, when you have several times you have a joint family trips out of town, your children, grandkids, and we sit down when the kids are gone, grandkids are gone to sleep, and sit down with our children and express our opinion. Now, it may differ. For example, in my case, my opinion is somewhat little different than my wife's Gita's opinion. So they're a little different, but the children know what our different feelings are. So it's important to do that. What your agent should know about you. This is the healthcare power of attorney. When they will have the power to act as your agent, how he or she can be your voice when you cannot speak for yourself, and what your agent needs to know about you, your values, your current healthcare status. So that is very important for them. It's nice to know, let your agent or your spouse or child know what healthcare issues you have so they can make an intelligent decision when you cannot. When you're ready, take the time to write out your thoughts. It may be helpful when you talk about your ongoing future healthcare wishes with your family and friends. What concern do you have about making decision for yourself later on in your life? Are there certain relationships that concerns you? Are you worried about being a burden to someone? How do you feel about others, especially the loved ones caring for you? What concern do you have about your health or future health care? Where do you want to receive your health care? What are your preferences? And what expectations about being cared for at home or any other locations? This is something I mentioned earlier, in India especially, and some people here, they prefer to go home and die amongst their family. What do you want to be with you? Whom do you want to talk to? And there are certain other things. We had a recent situation where this lady who was passing away, young lady with lung cancer, and she wanted to have one of our temple leader to chant the Gita songs, Gita, and we fulfilled that request. Um, an important consideration of aligning with one other group is whether the person is reversible or irreversible. Reversible and irreversible, we'll talk about this a little more, but this is kind of important. We have three groups here, and I don't know where you will fall, but the people in group A, some people say they only way they want to die, even if their condition is irreversible, is whether aggressive maximum medical treatment. Do everything. Irreversible means you have seen some situations where the people in coma for months have recovered completely. And we had some situations here amongst our friends who were on ventilators for 3-4 weeks and have recovered. Whereas uh, they're not irreversible, they're not recovered. Whereas reversible, they have recovered completely. Now, if you fall in group B, some people say that aggressive intervention is only for reversible condition, where I can, even after being in coma or in shock for 3-4 weeks or a month, I'll come back and I'll live a normal life. If they're not getting any better with a particular intervention, they would not want to continue it. And the group C people, some people feel strongly that they do not want any form of artificial life under any circumstances. So you have to decide which group do you fall and make that choice for you. What do you want your agent and your loved ones to know about your choices? Also, not only you make that choice, but let your agent also know what's your choice. Okay. Now you heard this term, do not resuscitate, DNR. And I'm sure if you have been in a hospital or your loved ones have been critically ill in the hospital, people will ask you, do you want a DNR? DNR is do not resuscitate order, is a legal order signed by a physician that specifies you do not want to be resuscitated in an emergency. Resuscitate in an emergency. Usually that means some of you might have experienced in the hospital, and several of us as a physicians have experienced that somebody's in the hospital, inpatient, suddenly stops breathing, the heart stops. They call it what is called as a code. Some different names are there. Some hospitals call it code 9. And a team of nurses and physicians come there, start giving a CPR, giving a resistant shocks. So when you sign that DNR, usually you have to discuss this with your physicians ahead of time. I do not want a DNR. Or your healthcare power of attorney will tell your physicians. And the physicians right there on the chart, please, this particular patient please do not DNR. So do not resuscitate. Don't call this code 999 if they stop breathing or heart stops. Of course, DNR orders are more common amongst people whose chances of surviving resuscitation is very low. DNR orders fall under the umbrella of advanced care planning, which provide details about the medical care you want to receive and when you cannot make any decision for yourself. A DNR order placed in a person's medical record by a doctor informs the medical staff that CPR should not be attempted. Because the CPR is not attempted, other resuscitative measures that follow it, such as electrical shocks to the heart and artificial respiration of a breathing tube, will be avoided. As part of the planning for seriously ill patients, doctors should discuss with seriously ill patients the possibility of cardiopulmonary arrest. That is when the heart stops and breathing ceases. Considering the immediate medical condition, describe the CPR procedure and likely outcomes, and ask patients about treatment preferences. If a person is incapable of making the decision about CPR, an authorized surrogate may make the decision. Some of these terms I think we need to address. What is brain death? Brain death is irreversible, not reversible, irreversible cessation of functions of the entire brain, including the brain stem. And we'll get to that brain stem. A person who has brain death is dead with no chances of revival. Of course, there are certain EEGs and all people can do to, the neurologist can recommend there's a total brain death. Coma is a very common term, we hear about it. A state of profound unresponsiveness because of severe illness or brain injury. Patients in coma do not open their eyes or speak, and they do not exhibit purposeful behaviors. Some patients need ventilators, while others do not. In general, coma lasts just a few days or weeks. Patients either die or regain consciousness, or in some cases, progress to a vegetative stage. And you mentioned coma, these patients I mentioned earlier, they were in a vegetative stage. The person has depressed consciousness, brain stem functions, and breathe without support. They don't respond anywhere, but they breathe and function and make some eye movements. And patient in vegetative state may respond to painful around loud sounds, go through sleep-wake cycles, and exhibit involuntary motions, the involuntary motion. A person in vegetative state for more than a year is considered to be a permanent vegetative state with extremely low chance of recovery. Of course, there are more terms. Patient's Self-Determination Act knows the right to die. Withholding and withdrawing. This is kind of also a term we need to learn more about it. Withdrawing means, withholding means, okay, do not resuscitate, do not put endotracheal tube, do not put respirator. But somebody who does not have a living will and is admitted to the hospital in a vegetative stage or coma, or even death, brain death, all our physicians are obligated to do a full resuscitation, including putting in an endotracheal tube and placing on a ventilator. Now, once they are on a ventilator and they do not have a living will, it's a very difficult situation for the family to make a decision to pull the plug, pull the tube endotracheal out and let the patient die. But if they have a living will, it makes it much easier for the family to make that decision. Of course, the next term is physician-assisted suicide and euthanasia, and we'll talk about this more in details. Reversible and irreversible, as I mentioned before. Okay, this is the term now we are hearing more and more in the last 8-10 years. What is death with dignity as an end of life option? Death with dignity is an end of life option governed by state legislation that allows certain people with a terminal illness to voluntarily and legally request and receive a prescription medication from their physician to hasten their death peacefully, humanly, and dignifiedly. What are the other terms used for physician-assisted suicide? Death with dignity is a term originating in the title of Oregon statute. And we'll talk about a little more about this, Oregon. Other terms used are physicians-assisted death, physicians-assisted dying, aid in dying, physicians' aid in dying, and medical aid in dying. Now, Oregon, as several of you know, was one of the first states in 1990 had this Dignity Act, Death with Dignity Act, allows competent adult Oregonians with a life expectancy of 6 months to ask their physician for a prescription of life-ending medications. The act requires a second opinion, 2 oral and 1 written requests, and a 15 days waiting period. It requires that a person be fully informed about the feasible alternatives, including but not limited to comfort care, hospice care, and pain control, as well as the diagnosis, prognosis, risk, and results. You know, Oregon, as I said, was the first state in 1990. And so far, this particular death to dignity has not been used in an appropriate manner and is well accepted, so much to so that 11 other states have acted this Death to Dignity Act. By convention, the physician-assisted suicide refers to a prescription of lethal medicine be voluntarily self-administered by the patient. You know, this can be given in 2 ways. They can give a pills, strong pills, which will definitely kill the patient, or they start an IV and give a IV medication to the patient who pushes the syringe and gets the IV medications. Of course, that is physician-assisted suicide is different from euthanasia. Very few countries, if any now, have approved euthanasia. Refers to deliberate, direct causation of death by a physician. I mean, we had some situations where the case where the intensive care nurses were killing the patient because the end of life, they were very miserable patients. And somehow or the other, they detected that these nurses were pushing these extra doses of morphine to kill the patient. And they were indicted and received strict punishment. It is important to distinguish between voluntary euthanasia, which refers to the patient-specific, consistent and thoroughly considered request by the patient, and involuntary euthanasia, in which the patient is killed against their will. This is, I was talking about those 2 ICU nurses killed the patient and they were caught, and I think they were imprisoned, these nurses. So that is illegal. Physician-assisted suicide or medical aid in dying is legal in 11 states: California, Colorado, District of Columbia, Hawaii, Montana, Maine, New Jersey, New Mexico, Oregon, Vermont, and Washington. One of our friends, I don't need to name him, is an elderly person who was really having a miserable life. Hey, Pramod, which state can I go nearby where I can die peacefully? We had a case here in Nashville where the I think this person contested for the mayor. He did not win the mayor's position about 5 years ago. Very educated, very well-known person, wanted to die. He was an end-of-life issue. There are a lot of issues he had, cancers and heart attacks. And so he wanted to die with the physician-assisted suicide, and Tennessee would not allow it. And there were back and forth, the lawsuits were going on. But eventually, he died of a natural cause. Of course, several of you know this famous guy, Kerouacian. Jack Kerouacian was an American pathologist and a euthanasia proponent. He publicly championed a terminal patient's right to die by physician-assisted suicide. Embodied in his quote, "Dying is not a crime." Kerouacian said that he assisted at least 130 patients. And some of you may remember there's lawsuits going on back and forth. And so one of the lawsuits, he was indicted and he was imprisoned, Kerouacian. Of course, you know this famous case. Jimmy Carter, as you heard recently, of course, Jimmy Carter, as you know, 12 years ago was diagnosed with melanoma, aggressive malignant melanoma, had a brain metastasis. Of course, he survived with the aggressive medical treatment. But as you know, recently, just 8-10 days ago, he, on his own, said, I want to be in a hospice care. And as you know, hospice care, we give a separate presentation on that. But it is for people who have end-of-life issue, less than 6 months to live. They don't get any aggressive medical care, but just a comfort care, pain medication and all. So Jimmy Carter is really open up this. And I hope more and more people learn some from his decision to be placed on a hospice care. After a series of short hospital stays, former President Jimmy Carter today decided to spend his remaining time at home with his family and friends, receive hospice care instead of additional medical intervention. He has the full support of his family and his medical team. So he has done two things: hospice care. Second thing, I want to die at home with my family and family and medical team. Of course, Tennessee law, effective May of 2017, the Advanced Directive for Healthcare form has combined the content of living will, advanced will, and I'll show you this medical power of attorney and appointment of healthcare into one model form adopted by the board. Advanced care directives are your written wishes about what you want to happen if you get too sick to be able to say. Advanced directives addresses issues regarding the issue of life-saving machines and medicines. Those keep people alive when they do not otherwise. A living will or advanced care plans need to be filled out while you can still think for yourself. These papers tell your friends and families what you want to happen to you if you get too sick to be able to say. Your papers had to be signed and witnessed. Of course, you don't need notarizing now. You can just get two of your friends to sign. In fact, we have a little friends group. We call it a beer group. We meet once a month in one of the Mexican restaurant. So I've taken this advanced directive and I'll show you this 5 wishes, excuse me, forms, and there within 20 minutes, everybody's sign and witness from 2 of our friends. Sorry, I got this little reflux. If your papers are witnessed, your paper will need to be signed in front of 2 people who will give your witnesses. These people, one of these people cannot be related to your blood by blood or marriage. You cannot receive anything you own after you die. Cannot be your doctor or any other staff who works in place where you get health care. Once they are signed by you, it is a rule. It stays like this unless you change your mind. And there's some practicality, I'll mention that in a minute, because you had to make several copies of this. If you fill out these papers, make 3 copies. 1 copy to your primary care provider to put in your medical file. 1 copy to the person who will make a medical decision for you. That is your healthcare power of attorney, your spouse or your child. Keep a copy with you to put with your important papers. You do not have to fill out these papers. It is your choice. You may want to talk to your lawyer or friend before you fill out these papers. Of course, it's ideally wise to review this every 3-4 years and revisit the situation. Your thinking may change after 4 or 5 years. So you want to think about this. Advance directive executed outside of the state by a non-resident of the state is valid as long as executed in compliance with the law of Tennessee. Now, this is a Tennessee form, and there are several advantages. You can actually go to the Google and type in Tennessee, Tennessee legal forms, a Tennessee advance directive form, and it's a 2 or 3 pages form, and it explains all the quality of life, permanent unconscious state. Sorry, I'm getting too many distractions here. Uh, your agent's name and quality of life, and permanent confusion depend on all activities of the daily living, end of stages. We all discussed this earlier, what you want, and the CPR, life treatment. Excuse me 1 second. Amit, can I call you back? I'm in a Zoom call. Sorry.
Something I need to attend.
Then life support, Amit is called. Can you call him?
Yeah.
So this I would recommend using this Tennessee form because it's very easy to fill it, and you can make several copies easily. Now, I personally one second. It kind of gives you all the different things, indicate your wishes of quality of life. I've indicated I would be willing to live with you if you adequate comfort care. I would not be willing to live with, and all these things we had discussed, yes or no, permanent consciousness, permanent confusion, depending on the activity of living. And these are all the same thing as a Tennessee form, and you have to sign here. So it's very easy. Now, personally, I have filled in these 5 wishes, and I given to my friend. It's a little more elaborate. The one technical, practical problem with 5 wishes is that the copies, there are 5, 6 pages, and you have to make copies and give it to all different people. So if you prefer 5 wishes, you can. It's a document, the completion of advance directory. Of course, you had to buy this, and we purchased this several of these copies, and we gave to us several of our seniors during our live sessions. But I think personally, I feel Tennessee form, and I'm sure other states have, like Seattle will have, Texas will have their own forms, and they're a little simple to use. So thank you for all this, and I'm going to stop sharing and open it for any questions. If somebody somebody's in the chat line, let me see. Somebody is asking, Satish Satte, will you get a copy of your presentation? Can it be downloaded from ICS website? Yes, we have made a recording of this presentation. Now, if you want the total presentation that also gives slides, just send me your email, and we'll put that in our ICSS website also, but that may take a week or 2 weeks to get in there. What is the difference between living will and healthcare power of attorney? Are they the same? The living will is your wishes, what you want. And healthcare power of attorney is the person acts as your agent, whether your spouse or one of your child, with your son or daughter, acts as your agent. So they're 2 different terms. A living will is what your wishes are. So that was the two chat lines. Let's open it up for audio things. Can you unmute yourself before you have any comments or questions? Please unmute yourself. Any, was it, I must say, either explain it very well or was very confusing. Did you have some question? We cannot hear you. For some reason, your audio is not working.
It-
Can you put in the chat line if you can? We cannot hear your audio. I think Mr. Mohan has a question, but I think his audio is not working. Just put in the chat line, type it in the chat line. He's trying to type it. Oh, by the way, for those who don't know our website, our website is www.icss.org. This is our website. So there are a lot of good information on this website. ICSS.org. Will a DNR prevent resuscitation in the event of car accident where the person is in coma? That's a good question, Kitu. Now, in a car accident, when the person is in coma, of course, somebody's coming. Sorry. In a car accident, when somebody's in a coma, there are different situations there because it depends on what age. It could be 21 years old, 40 years old, 60 years old. Whether this person has previously signed a DNR form, I mean, signed the living will form, not the advance directive. If they have previously signed the advance directives, and more importantly, if they are appointed the healthcare power of attorney or the agent for you, because you're in a coma, so you cannot make that decision. So, and if you do not have a living will, and the paramedics take you down to the emergency room, you're in a coma in an automobile accident. Of course, they had to do everything. If you stop breathing, they'll put an endotracheal tube and put you on a ventilator. Of course, your heart is beating at that time. If your heart stops beating, they will start a CPR and defibrillator and shocking you and all that. So it depends on a different situation. So will the DNR prevent resuscitation? If you already sign a living will and everybody knows about it, yes, and then the physician, they won't do it immediately in a day or two. After a patient settles down from the emergency room, goes to ICU, stays there for a few days, and then the physician will ask the family, the healthcare agent, not all the family. It's very confusing if you aren't too many family members. If they have a living will, hey, you want this DNR to be put in or not? And again, the person, if you looked at the three categories I had mentioned, that if you are in a category 1 where you want everything to be done, then of course you cannot put a DNR. But you are in a category where you want only if you are reversible, if you are irreversible, then you can sign a DNR. The DNR form has to be signed by a physician. Did you get that point there, Kiru? Yeah. Any other questions? We have several physicians here. Uma has something, I think she's one.
Yes, I have a question.
Yeah.
You have appointed an agent or the person who's responsible. But if both the people are unfortunately involved in an auto accident, so I'm sorry, I just think too much, right? So can you have more than one appointed person?
Yes, that's a good point. I'm going to stop the recording here.
Yeah.